Hello, and welcome to the Ministry of Government Relations webinar on planning fees. This webinar is intended to assist municipal administrators and councils in understanding what fees can be charged under the Planning and Development Act 2007. In this presentation, we will cover the legislation and regulations that enable local land use planning, what a zoning bylaw is, what fees can be charged under the Planning and Development Act 2007, and calculating, establishing, and applying planning fees. This webinar is based on the content of the Planning Fee Guide, which is available on saskatchewan.ca. The Planning and Development Act 2007 is the legislation that allows municipalities in Saskatchewan to undertake land use planning. The Act sets out the minimum standards for planning documents and also includes a variety of optional tools to assist municipalities in addressing complex development challenges. There are three regulations created under the authority of the Act: the dedicated land regulations, the subdivision regulations, and the statements of provincial interest regulations. The dedicated land regulations govern how dedicated lands, such as municipal reserves and environmental reserves, may be used, and how money from a dedicated lands account may be collected and spent. The subdivision regulations contain the review criteria for all subdivisions of land. Some of the regulations, such as minimum parcel sizes, do not apply if a municipality has its own zoning bylaw to govern those specific items. The statements of provincial interest regulations contain 16 policy areas where the province and municipalities have a shared interest. The regulations assign objective-based policy statements to these areas, and planning documents and decisions must incorporate them insofar as is practical. Under the Act, municipalities may adopt municipal planning bylaws. The term municipal planning bylaws refers to district plans, official community plans, and zoning bylaws. A district plan is a statutory plan adopted by two or more municipalities that form a planning district. The district plan guides development in those areas agreed to by the municipalities. An official community plan is a statutory plan which contains the long-term vision and goals for a community in the form of policy statements. The zoning bylaw is the primary tool for implementing the district plan and official community plan. It does so by organizing land uses and development to meet broader community objectives. Let's examine zoning bylaws in more detail. The purpose of a zoning bylaw is to organize the use of land for the health, safety, and general welfare of the community as a whole. Historically, this meant separating land uses which were incompatible, such as high polluting industries, from where people lived. Zoning has evolved over time to become more complex than just the separation of land uses, with the intent to go beyond health and safety to create amenity and a high quality of life for the inhabitants of a community. A zoning bylaw organizes development by dividing a municipality into zones using the map attached to the bylaw. In each zoning district, there's a list of permitted land uses that can be established in the zone. There may also be a list of discretionary land uses that may be established in those areas with council's approval. Any land use which is not listed as either permitted or discretionary is considered prohibited in that zone. Each zoning district may prescribe development standards for the entire zone or for each land use individually. For example, building setbacks from property lines or maximum height. A zoning bylaw will also establish a procedure for making and processing applications for minor variances. Minor variances provide council or the development officer some flexibility when regulating development under the zoning bylaw, allowing the minimum setback of a building to a property line and the minimum distance between buildings to be reduced by up to 10%. To make changes to either the text of the bylaw or the attached map, a municipality must undertake a structured bylaw amendment process. Under Section 51 of the Act, a council may establish either in a zoning bylaw or a separate fee bylaw a schedule of fees for the application, review, advertising, approval, enforcement, regulation, and issuance of a development permit, a discretionary use, a minor variance, and an amendment to a district plan, official community plan, or zoning bylaw. We will talk more about how these fees can be calculated later in this workshop, but generally, they must be set at cost recovery and cannot be used to generate revenue for the municipality. Certain zoning related matters can be appealed to municipalities' local development appeals board, and a municipality may establish a fee for those applications. While not listed under Section 51 of the Act, development appeal application fees are typically included in planning fee bylaws for ease of use. The Act allows municipalities to charge a maximum appeal application fee of $300 for the review to ensure appeals remain attainable for all applicants. Most development appeals boards are composed of volunteers appointed by council who may receive an honorarium for their time. This helps to keep the administrative costs of appeals low. In addition to administrative costs for reviewing development proposals, municipalities may also incur capital infrastructure costs associated with new development. Part 8 of the Act addresses the mechanisms available to municipalities to recover specific infrastructure related costs. Fees under this part are not eligible to be included in a planning fee bylaw. Calculating fees under Part 8 should involve a servicing study to identify the infrastructure needed to accommodate growth. Planning fees allow for a municipality to recoup costs associated with certain applications. To recoup costs appropriately, a municipality should understand how much time staff spends reviewing applications, issuing and enforcing permits, and conducting on site inspections. Another important aspect is how much money is spent on mapping or drafting services, and the cost of advertising associated with each application type. If a municipality chooses to use a third-party consultant for the review of applications, they should work with their consultant to determine appropriate fees based on the consultant's hourly rate. It is important to note that if a municipality utilizes a consultant for other tasks outside of the eligible processes listed in Section 51 of the Act, these costs cannot be included in any prescribed fees. Fees should be reviewed regularly to ensure they remain accurate. Municipalities may find it beneficial to keep track of the amount of review time required for each application type to assist with conducting reviews of the established fee. There are a variety of ways a municipality may choose to calculate planning fees. As mentioned, most methods require some form of estimation or tracking of the time it takes an administrator or other employees to review each type of application. The most common approach for calculating fees is to use the average review time multiplied by the wage of the staff reviewing the application. For example, if a simple permitted use permit takes 2 hours to review and the staff wage is $50 an hour, then the permitted use permit fee would be $100. This approach can be taken to calculate fees for each type of permit, land use, or application. If this method is used, it is important that a municipality also consider costs outside of the application review, including enforcement, site inspection, and the issuance of approvals. As applications can vary in type, size, and complexity, a second option for calculating fees is to use a fee range based on the expected complexity of the application. This method is typically considered to be more accurate from a cost recovery perspective. Using this method, the council may choose to charge a fee for each subcategory of the application. For example, a development permit for a permitted use may have a lesser fee than a discretionary use. Some discretionary land uses may also require a more comprehensive review than others. In those cases, the council may choose to distinguish between more complex reviews and set their fees accordingly. Council may also find that amending the official community plan to include a concept plan takes more staff time compared to amending an OCP future land use map, and reflect this by creating categories of OCP amendments with appropriate fees. If using this method, it is important to clarify in the bylaw containing the fees which land uses are considered more complex. Certain items cannot be included in the planning fee bylaw, including council meetings or public hearings. Both council meetings and public hearings are required in legislation as part of normal operations for a municipality. The cost of these meetings cannot be charged back to the applicant. Time spent reviewing general development inquiries. When a municipality adopts planning bylaws, they are responsible for administering those bylaws and responding to inquiries on development within their jurisdiction. The time spent responding to these inquiries cannot be recouped through planning fees. Other items that can't be addressed in a planning fee bylaw include the review of subdivision applications. Only municipalities designated as an approving authority may charge a subdivision fee. Municipalities can shift some of the review that may be associated with a subdivision to other fees authorized in the Act. For example, a municipality should review the adequacy of a site for a proposed use, such as how it will be serviced when a developer applies for a zoning bylaw amendment. Infrastructure and services. As these items may be collected through a development levy bylaw or servicing agreement, they cannot be listed as a planning fee. And the upfront cost of adopting a new district plan, official community plan, or zoning bylaw benefit the community as a whole and cannot be included in a planning fee bylaw. In accordance with Section 51 of the Act, fees can be prescribed in either a zoning bylaw or in a separate fee bylaw. A council must comply with the public participation requirements of Part 10 of the Act when amending, adopting, or repealing a fee bylaw. Under Part 10, a public hearing must be held after council gives first reading to a bylaw. In addition, public notice of the bylaw must be given, and this notice must meet the minimum requirements, including a newspaper advertisement circulated once each week for 2 consecutive weeks. This public notice must include a general description of the proposed bylaw and the reasons for it, when and where the public can examine the proposed bylaw, the date, time, and location of when public hearing will take place, and a general description of public hearing procedures. For example, each person may be given 5 minutes to make a representation to council. When a council prescribes planning fees, either through a zoning bylaw or separate bylaw, it must first be accompanied by a planning fee rationale document. This document should justify the prescribed fees and detail how the application fee was determined. This rationale helps to make planning fees transparent and can reduce the opportunity for municipalities to be challenged on those fees. A planning fee rationale sample document can be found on Saskatchewan.ca. Once a planning fee bylaw and the rationale document have been adopted, a certified copy must be filed with the Director of Community Planning within 15 days of the bylaw being passed. A planning fee bylaw is exempt from obtaining ministerial approval. Planning fees should be collected at the time of application to reduce the potential for non-payment later. If an applicant has not paid review fees at the time of application, the municipality has little recourse to seek collection post-approval. For example, planning fees under Section 51 are not eligible to be added to municipal property taxes in the same ways other fees under the municipal acts may be. There is also no authority in the Act for a municipality to charge interest on any unpaid planning fees. There is less risk to the municipality when fees are collected at the time of application and before any work has been done to review the application. Applicants should be aware of the full cost of their application before they apply, which increases transparency and reduces chances of non-payment. If an application takes longer to review or exceeds the initial amount collected through the planning application fee, the municipality is unable to request payment of additional fees. This highlights the importance of establishing an appropriate amount in the planning fee bylaw. If an applicant substantially changes their proposal in the middle of the process, the municipality may choose to charge a second application fee to review the new proposal. As a wrap-up to today's webinar, we can reflect on a few key messages. Planning fees authorized under the Act are a way for municipalities to recoup costs associated with certain applications. Municipalities also have the flexibility in their approach to fees. Some communities choose to balance cost sharing with cost recovery as a way to help facilitate growth and development in the community. Others apply a cost recovery approach but utilize tax incentives to achieve the same goal. Regardless of the approach taken, it is important for every municipality to understand the costs and benefits associated with their choice. Regardless of what approach a municipality takes, fees should be transparent, and the entire application cost should be charged in the initial fee paid by the applicant. Finally, in the interest of transparency, a zoning bylaw that includes planning fees or a separate planning fee bylaw must include a rationale document. This concludes the webinar on planning fees. If you have any questions about the content of this webinar, please contact the Community Planning Branch using the information shown on screen. Additional resources, such as the Planning Fee Guide and the Planning Fee Rationale Sample, may be found on Saskatchewan.ca. Thanks for watching.